What I'm going to do tonight is make sure that, I'm not speaking too loudly into this thing, that is to really try and give you a bit of a structural overview. And as I look across the room, I'm quite aware that we've been doing quite a lot of speaking within the broader marketplace over the last few months about some of the changes that are about to come upon us. And so I'm aware that some of you will have attended those, as others who won't have. The intention of what I'm about to take you across tonight is more the broad legislative structural changes and I suppose the context within which you would be, as service providers, providing treatment to people or services to people so that you have a contextual understanding of that. Having been in that sort of situation myself in the past, it clearly is important for you to understand some of that context within which you're applying your trade, so to speak, so that you can help, I suppose, understand the context not only of what you're working within, but managing the expectations of the people you're trying to assist. Okay? So, to begin with, okay, so what I've got, I'm already blowing this. All right, so you would be well and truly aware that we don't come under the banner of WorkCover South Australia anymore, by the signs all around you, and that's it's obviously not just about making sure have us sort of have a name change for the sake of it. It clearly aligns with our new legislation of the Return to Work Act, but it's in itself gives you a bit of an understanding of the functional orientation and the more active orientation of the direction we're trying to take our scheme. So I don't want to spend too much time talking about name changes, but really spend more time now talking about, I suppose, the focus of where we're trying to go. The scheme itself commences from the 1st of July. There are elements of our legislation which have effectively been proclaimed or enabled to start before the 1st of July to enable us to have the whole scheme and ready to go on the 1st. That being said, if you're thinking about the last dot point that I've got down there about it applying to new claims, there are transitional arrangements which I'll speak about very soon, which clearly mean that for a person who has a claim which is pre-1 July, it doesn't mean the world ends for them. They move into the new scheme with some special rules of the game in it for those people in terms of what happens for their claims in and around that, and I'll speak about those shortly. So again, you've got a good understanding of what happens, but what you can be sure of is that they don't fall off a cliff on the 1st of July. There's still services being provided to those people. If I look at it in terms of the principles of service that underpin where we're going, which are coming up here at the moment, one of the unique features of the piece of legislation that we've got to work with and then apply the series of programs and services that are otherwise available is that we have service standards enshrined within that legislation. So often pieces of legislation are otherwise what I would describe as very dry descriptions of what I would otherwise describe as a minimum level of acceptable performance for all the key players. What this attempts to do is take us beyond just a prescription of the minimum level of acceptable performance and even talks about concepts like the spirit of the standards. Now there's a bit of beeping going on and around me here, which I don't know whether that's saying... Very good. Okay. All right. So if I come back to that, there's some key words that you'll see on the screen behind me here that talk about early and timely intervention, service standards, face-to-face service wherever possible, and where it's required, which are elements of that. And really fundamentally what it comes down to is, and I think it's section 14, and I'm sorry to sound like a bit of a legislation nerd when I start rattling off sections of a new piece of legislation that we're about to work with, but that talks about the spirit of the standards. But ultimately it's about us all actively. When I say us all, it's talking about workers, employers, service providers, and the compensating authorities being the claims agents and or self-insured employers, really making sure that they're actively getting in a very timely way to make sure that there's intense service provision that's in keeping with what it is that we're trying to achieve here by way of health benefits for the people who are in and around this scheme. So the transition that we're trying to create here is not about necessarily focusing on the cost benefits that are associated with this, and I truly believe in the concepts that are about in and around the health benefits of work. I know Gavin, who's an occupational medicine physician, and others will talk about the position statements from the relative the occupational and environmental medicine group that have otherwise put out, that make sure that we're well and truly aware of the evidence base that provides an underpinning to what we're doing to make sure that we're really trying to get out there and get people back to work as soon as possible, because we know that it's bad for people's health to be away from work for extended periods of time. We're absolutely committed to that. So what I'm going to talk about are now the parameters within which some of the services that are going to be provided will apply. Rob Cordner, who hasn't quite arrived yet, but Rob will speak to you a little later about the way in which our claims agents will be seeking to apply those particular services. And whilst it's not a focus of what I'm talking about tonight, I'm more than happy to answer questions about how this actually applies or what it means for self-insured employers in our sector. We have a large proportion of self-insured employers in South Australia relative to many other schemes, and so they're relevant questions in that space. But you can take it that the rules of the game that I'm about to talk about that apply to ReturnToWorkSA are the same rules that apply to self-insured employers in this state. Okay? All right. So we'll start at the beginning with respect to chronologically just how we will experience a claim emerging or a person getting hurt in a particular workplace, making sure that you understand some of these changed contexts. So the compensability tests within our scheme have changed and they're stronger. Okay? Now, I'll try and walk you through just very briefly what that looks like. So for physical injuries, we've gone from a situation where essentially if a person sustained an injury and they were at work, it was effectively compensable. Whereas now there is a test of significance, or employment being a significant contributing cause. That aligns more with what you'd see in most of the other jurisdictions. We had quite a low bar in terms of physical injuries in the workplace, in terms of what was compensable or what wasn't. What I will tell you is that those particular words of themselves still don't create an unnecessarily high bar, I guess, or an extremely high bar, because it doesn't mean it needs to be the significant contributing factor, which we'll talk about in the psychological injury claim space, which is some different influences on what actually happens. But when we talk about it in terms of a physical injury, having worked in a jurisdiction where this is a very similar sort of definition, it may well be that there's a number of significant contributing causes to someone having suffered a particular injury. It just means that work needs to have some sort of significance other than it occurring just whilst a person was there. So if I give you an example, we might have a person who might have suffered the onset of knee symptoms whilst they're at work, or knee pain that they might not have otherwise experienced previously. They might have significant underlying degenerative issues. They might even have some sort of unrepaired previous injury that's quite evident that was there in that environment. And let's say it was me in a relatively sedentary work environment. Sitting at my desk, I go for a wander down to get a cup of coffee or something like that, and I get the onset of symptom or pain in my knee. It'd probably be a pretty long bow for me to draw to try and suggest that work was necessarily a significant contributing cause to my knee injury in that type of context. If I was just walking down a relatively straightforward corridor, it could have happened anywhere. It's not necessarily work that's contributed to it. But obviously, if it was a very different set of circumstances where perhaps I was in an underground mining environment, walking on lots of uneven ground at the time that it happened, probably a pretty good chance that work was a significant contributing cause or otherwise to my type of injury there. It's just an example, but what it tends to suggest that the significance test has risen, but not a great deal in terms of the physical injuries. If we talk about psychiatric injuries, it's a different set of circumstances altogether. There's one additional word there in how we define a compensable psychological injury, which is highly relevant, and that's the word "the." It talks about the employment being the significant contributing factor. And without going too far into whether that's right, wrong or otherwise, it's about acknowledging the fact that there are such a wide variety of potential catalysts or circumstances that might otherwise influence a person's emotional, psychological, psychiatric status that may be beyond the work environment. And to give you a bit of an example of how this may or may not be applicable, might be in a circumstance where a particular person who's let's say might be an otherwise quite cognitively or emotionally demanding type of work environment that's been that way for quite some time or otherwise, and there might be some other significant life event or stressful life event that goes on, such as the death of a family member or a relationship breakdown or any of the sorts of things that might otherwise be quite relevant stressful life events, and their response to their work environment suddenly is such that they're not otherwise coping in that particular work environment to the point where they absolutely have a diagnosable condition, but whether work was the significant contributing factor that was the cause of that particular condition, it starts to become debatable potentially in those types of circumstances. So it's about trying to isolate it to those incidences where work really is the significant contributing cause with respect to psychological injury. Okay, if I talk about a personal approach now to exactly what's happening here, I don't want to spend too much time on this because this is some of the sort of information that Rob will talk about that links strongly to the service reforms and the way in which we'll provide service to people under the new scheme that we have. But it's safe to say that you can see from the symbols and the key words up there that there's a strong focus on early and tailored individualised support. You would have heard a lot about, I'm sure, some of the mobilised services that will be provided by our claims agents in and around the sorts of case management services that will look very different, feel very different, and involve some face-to-face support that you'll see on the right-hand side of the screen up there. And the intent of that clearly is about making sure that it's not a one-size-fits-all. There's not much point in us turning up out there in workplaces and meeting with people and applying a recipe. We need to be out there and discussing the relative situation or the specific circumstances with the employers and the workers who've been hurt. And I think it's really important to remember that a large part of what we're doing in that environment is clearly making sure that the person who's been hurt has an understanding of what they can expect and how we might otherwise be able to assist them and link them into other sorts of services that might provide assistance to them depending upon the barriers they might be about to face, but also providing some assistance to the employers in those circumstances. South Australia we have about 50,000 employers who are registered with us from an insurance perspective, but 44,000 of those are effectively small businesses. And so the frequency with which they actually have claims occurring in their workplaces is extremely small. And statistically, I think it's as low as once every 14 years if you were to apply it to all of those. Now, obviously, that's a statistical cross-section that we're talking about, and there's going to be some employers who clearly experience claims more frequently than that. But there's quite a number who don't, and we have an employer who's not knowing what's potentially going on, and then a worker who's more at risk on account of that. So making sure that we're out there, but I won't steal any more of Rob's thunder in terms of the sorts of things that he'll talk about in a very short period of time. So if I move on from there and talk about how services are, I guess the provision of services is differentiated within our new scheme across those who are what's classified or described as seriously injured, and I know this slide says non-seriously injured, and I know that the people who are hurt themselves would never consider their injury potentially to be non-serious, but it helps us to describe the cohorts for the purposes of explaining the entitlements that are otherwise there or the support that's otherwise there for people in this new environment. But if we talk about, and I'll talk about the delineator of how we actually get to seriously injured or otherwise in a new scheme in a moment, but for those who are considered to not have or be in that seriously injured cohort, one of the biggest changes to our scheme is the time banding of the income support that's available to people. So what will happen is that those people will have income support available to them for 2 years. What the slide says there is up to 3 years of reasonably incurred treatment, care and support services. It's really important to emphasise it's not necessarily 3 years, it's 12 months beyond when income support ceases. So it may be 3 years if a person's on income support for 2 years, but the services that most of you would be providing in this particular room here, I'm sure, are the sorts of services would be available to people for a year beyond when they've, for all intent and purpose, as what this really implies, is gone back to work in a full-time capacity and they're not requiring any sort of income support at that particular stage. So There are some exceptions where it's foreseeable that a person might require some sort of surgical treatment for a condition at a point in time down the track, where those sorts of things can be acknowledged and pre-approved to the point where they can be, their claim is effectively reopened for a period of time at some point again in the future beyond those 2 years, on those time frames that we're talking about up there. So if I talk about what the slide then refers to is that the 3 years of return to work services, including the early access to retraining for new job or new employers, referral to return to work service providers, referral to job placement services, all those types of services that are otherwise provided within our current scheme will continue to be available to people. Reconnect is mentioned up there, and I won't spend a lot of time on it this evening, but it's really about making sure that we have a service that's there for people to help transition them back into the broader community if and when they need it. We're not anticipating there are going to be large tranches of people, particularly with the intensity of service provision that will be provided to people under the new scheme, that will necessarily require this service. But a criticism of our scheme, even as it currently is, without any time banding as such, is when income support stops, that people often can feel abandoned, and particularly when they've spent a significant period of time almost seeking guidance and working within a compensable scheme where they have points of contact and people to assist them when those supports otherwise go. And it's about making sure through this Reconnect service we effectively have people who are trained and across the various range of community support services, access to the various different sort of plethora of Centrelink provided services or otherwise, to try and be a point of contact to assist people in these sorts of circumstances. It's a service that won't be provided by claims agents. It's a service that will be available whether a person's suffered their injury, whether they're employed by a self-insured employer, whether that's with the Crown agencies, private business, or whether or not they've been covered by a claims agent or one of the employers who's insured with ReturnToWorkSA. Okay, so this is the workers who are classified as seriously injured under our new rules of the game as legislated. So 30% whole person impairment is what defines whether or not a person is considered to be seriously injured within our new scheme, within our new rules, I suppose. And as many of you would be aware, particularly if you've worked in and around impairment, it's probably not a perfect descriptor of whether or not someone necessarily would otherwise be considered seriously injured, because impairment isn't necessarily directly correlated with the level of disability a person may or may not have. But one of the reasons, I suppose, that it's been decided upon by the legislators, as opposed to alternative means of trying to ascertain whether or not someone should be considered seriously injured or not, is it's a relatively objective assessment. And there can be less dispute in and around it. And when we look at some of the goals that the legislators had, and we look at the objectives of our act, minimising disputes is core to that. And so part of what we wanted to have was a system or a method of trying to work out who best receives the lifetime access to income support, I shouldn't say lifetime, through to retirement age in terms of income support, and the lifetime care and support that otherwise goes with that. That was the defining factor or criteria that was applied within our particular jurisdiction. So if we think about that more broadly then, it's an incredibly important linchpin in how we define what benefits are available to people. And it's really important for you to understand that as service providers to people as well, in terms of managing and helping to understand people's expectations in that space. We will be talking a little bit more later this evening, and Trish Bowe is going to talk to you a bit about the systems that we have in place to try and make sure that there's as much integrity in and around that decision making as possible. We want to make sure that we don't have people erroneously either in or out of that particular serious injury cohort who shouldn't be. There'll be people who might, for example, be assessed at a level that's lower than 30%, and it's based on an incorrect assessment. That shouldn't be the case, and they should be entitled to receive the support that's otherwise available. And the flip side, we also have a situation where people could potentially be erroneously assessed as being greater than 30%, and we need to make sure that the intention of the Act is followed up on and followed through on, and that the people who receive the services are actually the people who should be receiving those services. But I won't go too much further into that, other than to say that If I sort of traverse across the self-insured space now as well, one of the things which will pose a significant challenge not only to us but particularly to our self-insured employers as well is just, and one of the things that we've been putting the challenge directly to them in and around is how they're going to otherwise plan for providing the lifetime care and support for these people with serious injuries. You might say that's there at the moment in terms of what they need to otherwise provide. The difference is at the moment in terms of what the legislation allows for or otherwise is that lifetime care and support can otherwise be packaged up into a lump sum and handed over to that particular person with the liability bearer, being the insurer, then absolving themselves of responsibility for what happens in that space. It's actually not allowed for within our new legislation. There's very good reasons for that. That relate to funding in and around the National Injury Insurance Scheme and the NDIS, that relate to double dipping concepts that I don't want to go into right now because it gets into the technical funding arrangement or rules that we have to play by. But it's really important to understand that, and that we are taking that really seriously, both internally, and again, Rob may allude to it with respect to the service model later on about what we're doing internally in terms of how we actually manage those within the serious injury cohort who are otherwise what we would describe as catastrophically injured. There are plenty of people who will come in at sort of between 30 and 40% who otherwise don't require or want us overly actively involved in their lives. But there will be those who are catastrophically injured who tend to sort of kick in if we were to draw a correlation more towards the sort of 40 to 50% mark, particularly when we're talking about physical injuries, who would require that far greater intensity of service that might relate to things like attendant care, etc., within their home. So it just, again, gives you a little bit of context around that. So one of the things that I think was on that screen there before, which I didn't speak about, was also the importance of that threshold with respect to the access to common law. So if it comes up later in the slides, so be it, I'll skip over it, but I'll just give you a bit of information in and around it at the moment. Common law was introduced as a feature of our scheme with this tranche of changes that's been introduced. When the changes were first mooted, it was suggested potentially that it might come in at a significantly lower threshold in terms of the relative seriousness of a person's injury. There was lots of opposition to that from many different quarters, and really what much of that related to was the potentially adverse health impacts it has on people in and around the industrially adverse situation it creates when you effectively have to sue for negligence. But one of the points that I wanted to make in and around the availability of common law, which is available above 30%, when I use terms like availability, there's a really important key differentiator here between statutory benefits that a person's entitled to and then common law, access to common law. Access to common law only entitles you to basically have the argument or sue for those damages. There has to be negligence demonstrated on the part of the employer for common law damages to be awarded, okay? Because those common law damages are effectively awarded against the employer in that type of instance. Now, that's, again, that situation where we get into that very adversarial situation that starts to occur in the courts, but really the point that I want to make around that is there's no guarantees in that space. And once a person elects to go down the path of pursuing common law damages and suing their employer, they're only suing for economic loss. They can't sue for the other care and support or otherwise. And remembering that this is a scheme where if they're 30% or more, they would receive, and you'll see the income component up here, 80% of their notional weekly earnings through to retirement age guaranteed anyway. If they choose to go common law, they put that at risk. You can't then say, okay, I want to pursue common law. That didn't quite work out the way that I wanted it to, so therefore I'm going to now revert back to the income support that's otherwise available through the scheme. Okay, so we don't foresee that there will be large proportions of the population otherwise pursuing common law on account of some of those sorts of reasons, because people have to make meritorious decisions in and around what the prospects of success or otherwise are in and around that. And they also have to think about it in the context of whether or not they want to necessarily have that fight, I suppose, for something which they're otherwise entitled to for a large part. The people who may be motivated to do that are probably those people who conceptually might be working in relatively low-paid, casual or part-time employment, perhaps whilst they're studying. They might be studying, probably the stereotypical example, I'll use the medicine example here, where they might otherwise expect to earn significantly more than they might be during whatever casual employment within which they were injured at the time is. And what they're actually paid 80% of in terms of notional weekly earnings clearly relates to whatever employment they were in at the time of the injury. So those people might be highly motivated to otherwise pursue common law if there was negligence that was able to be established in that type of environment. But again, it's entirely plausible it will be happening, but when we put this into some more context for you, in terms of the people who are actually classified as 30% or more whole person impaired in our current scheme, and remembering that the only people who are getting these assessments at present are people with physical injuries, we're talking about 50 out of the 15,000 or so claims a year. Okay, so we're not talking really large numbers here of people who actually get to that type of level, at least in terms of physical injury, where we have some sort of experience upon which to base that. Okay, now I've taken lots of time more, so I'm going to start getting through this a little bit more quickly for people, but and please let me know if you think this is, I'm telling you how to suck eggs here. So some of the information up here that I've just gone in and around is the fact that a person receives 100% of their notional weekly earnings for 12 months under the new legislation. Under the existing legislation, people receive that for 13 weeks. For the next 13 weeks, they would receive 90%, and then thereafter, they would revert to the 80%. Okay? The current scheme, it relates to cumulative periods of income maintenance that people receive. So without going into too much detail, what that really means is 13 weeks might be 13 weeks, but not as you know it. It could be that if, for example, that cumulative period of 13 weeks is thought of in terms of entitlement periods, that it takes much longer to go through that. Whereas the new scheme talks about elapsed time from the point at which the person has their first period of incapacity. Okay, so it's much more definable and identifiable and readily known for all concerned as to when those boundaries are about to occur. So if I just quickly mention the fact that there's a new work capacity certificate, I won't go into too much detail other than to say that if I was to leave you with two messages in and around the work capacity certificate, and the name probably suggests part of this, is that there's a very strong focus on trying to enable and encourage practitioners in our scheme to be prescribing function. Okay, we understand, and I know Gavin uses the words prescribing it as much as anything, but when I've historically spoken about encouraging function, but we all know about the relative dangers to people's health of excessive periods of, I guess, passive sedentary, just waiting, I suppose, and the deconditioning that can occur in and around that, and the dangers that poses to people's health. So the prescription of function, and the other part is about managing people's expectations. One thing that's probably not lost again on this room is that the recovery periods for people in compensated environments are significantly longer than people in non-compensated environments. And for whatever the reasons are, we think it's incredibly important to help manage people's expectations around what are normal sorts of recovery times around which we would expect you to be able to get moving or otherwise, and moving on with your life in a way that's healthy. Impairment assessments, I'm not going to talk about in any detail because Trish is going to be speaking about those towards the end of the session this evening, so I might jump over those. But other than, it's probably sufficient to say that we've got some new impairment assessment guidelines. We're training a lot of, when I say a lot, is it 190 or so, Trish? Accredited permanent impairment assessors at present. When I say at present, I don't mean this evening, but over the course of we've been doing it over the last month or so, and over the next month or so we should get through most of the impairment assessors with respect to what applies to them. The most significant change that we have is that we have psychological injury able to be rated within our new scheme in terms of permanent impairment, and it will be rated purely in and around the thresholds for access to the serious injury provision of benefits that are contained as part of the package. The lump sum payments, this is really important for people to get a bit of an understanding of, and you might think, well, hang on a second, I provide health and health-related services to people. What do I need to know about what payments are available to people or otherwise? I think you need to know about them from the context that it actually can significantly impact people's, again, their expectations and just their relative psychological well-being, and what you get a bit of an understanding of what the sorts of things that people are thinking about are. I don't know about you, but I think about my personal financial situation quite a bit. We all do. We've got families, mortgages or otherwise, and there is just significantly more money at stake with these lump sums in our new scheme. It's far more generous than it historically was, but far more generous doesn't mean any less stressful. People feel as though there's more riding on these things or otherwise. So we've got a situation where people have always received what's referred to as a non-economic loss lump sum. So they have a statutory entitlement. It doesn't necessarily relate to any level of disability. It's just such that if they have a certain level of permanent impairment, they are able to access a lump sum of funds. Now, in our current scheme, that's what people receive. People receive the maximum amount that's available, which is $480,000, and I've got some amounts for you on a slide that's coming up, which again allows you to contextualise some of this. It's at 70% that the person that actually has the maximum amount of fund, or 70% whole person impairment, that the maximum amount is available to people. In the new scheme, the maximum amount becomes available at 50%. So in other words, the trajectory of the availability of funds, I guess, if you were to look at it on a scale, has just increased. So in terms of what's available to people at relatively lower levels of whole person impairment. The other significant part of our scheme which has changed, which is again quite unique, is the concept of an economic loss lump sum. The economic loss lump sum theory is that if someone has received a whole person impairment of somewhere between 5 and 29%, that there is a potential for that impairment to impact their income earning potential at some stage in their life. Irrespective of whether it does or it doesn't, they don't have to go to court to have a fight in and around this. They will receive a statutory allocation of funds as an economic loss lump sum. At 30% or more, that's not available because we actually provide people with their income support through to retirement age. But at 25 to 29%, we don't. But there is a chunk of money, literally, that's available to people that's linked to their whole person impairment amount. It's linked to their age, and it's linked to the number of hours the person works. So I won't go into the details as such, other than it's sufficient to say, given that it's in effect meant to be there to compensate for some potential loss of income, it's discounted for age. The discounting starts from the age of 25, and then basically through to the age of 69, it's significantly less thereof, okay, in terms of if we relate that back to retirement ages and the like. Chris?
Michael, so at what stage does a lump sum payment like that kick in? Because looking at when a person can be assessed as being, it can be early or late in the process. So have you been thinking about sort of any sort of time period when you can actually make that assessment? Sure.
So there's no one answer to it, but conceptually, the impairment or the permanent impairment, as it probably is a bit of a hint, once the injury is stabilised to the point where and the terminology that's used within the relevant guides has reached maximum medical improvement, that's when the person's injury is at a stage where it's able to be assessed. It might be such that for some of the more serious, and for the vast majority of injuries, I'll start by saying that's going to happen well and truly within the 2 years. There still will be some injuries, acquired brain injuries, neural injuries and the like, that may well not stabilise within those 2 years or otherwise. And it may well be such that if the person is anywhere near being likely to be able to be in that seriously injured cohort, that some sort of preliminary assessment, but is not the assessment per se, needs to be made in terms of deeming or otherwise as to whether someone may or may not fall into that category. But for all intent and purpose, it will be a medically informed decision in and around when a person's conditions reached maximum medical improvement or stabilised. Okay, so if a person puts up their hand, the injured person says, I want to be assessed at this particular point in time, and based upon the experience of the person within the claims agent or the self-insured employer, it seems perhaps a little bit early. They might not necessarily be saying no, they might say, okay, we need to get a bit of medical input as to whether or not it's actually your injury stabilised to the point where we can make this assessment here and now or otherwise. And that could go both ways. Okay, so this just gives you a bit of an idea of the sorts of amounts of money that are potentially available, and why I indicated before that this might be something that's weighing on your client, patient, customer, whatever you want to describe the people you work with as, why it may weigh on their minds at different points in time. So just to give you a bit of an understanding of, I won't go through all of these examples, but if I was to look at the one that's in the middle there, a person who has a 20% whole person impairment, they're 25 years of age, working full time. At the moment, under a current scheme, they'd receive a non-economic loss lump sum of $45,792. Okay, if we look at it under the new scheme, they would receive a slightly larger, but not much larger, non-economic loss lump sum. But look at the economic loss lump sum that sits to the right of that. That's another $153,000. So if we can compare it, we're looking at the difference between a bit over $45,500 and almost $200,000. These are significant differences that are available. So it's incredibly generous in that sense, but it's just important for you to have an appreciation of this is what can be happening in and around your treatment of people that you're dealing with. I've already touched on access to common law for economic loss. So I'm not going to go through that any further because I believe I've already gone over my allocated period of time. So sufficient to say, and again I'm just going to skip through this, that we also have a new premium system that's been introduced, which is largely about ensuring that it's simplified for employers and focused on encouraging them to be receptive to and otherwise incentivised to bring people back to work in their environments, whereby the only moving part for them is income support. So it's incredibly predictable for them, and they know the best thing that they can do to impact their premium is to otherwise bring people back into their work environments without too many other moving parts. Okay? It's a single system that will be applied across the scheme, as opposed to the experience rating scheme that we've historically had, which is only applied to 6,000 of the 50,000 employers in our scheme. Okay? So the potential for it to influence in a positive way employer behaviour in terms of their receptiveness to bringing people back into their work environment has improved. And I think that what I'm going to do is just skip through and bring you into a bit of a slide which summarises where we've been.
Australian employers with insurance to protect their business and their workers in the event of a work-related injury. We support people who have been injured by providing financial support, which covers wages, access to reasonable medical treatment, and a range of return-to-work services to help them recover and return to work as soon as they can. The scheme is funded by employers who pay an annual insurance premium. An employer's insurance premium is calculated based on the remuneration they pay workers, a risk rating for the industry they operate in, and any income support costs for the previous year. When recovery from an injury is likely to take longer than 2 weeks, a mobile case manager will visit the worker and employer as soon as possible to assist. The case manager will continue to meet face-to-face throughout the recovery and return to work journey. This way, we can provide the worker with the support and services they need to recover from their injury and return to work as soon as possible. Financial support to cover a worker's wage is provided for up to 2 years and up to 3 years for medical and return to work services. If someone is off work for a long time, they will receive 100% of their average weekly earnings for the first year. This reduces to 80% in the second year before income support stops. For anyone seriously injured, we provide a tailored program of lifetime support to suit their specific needs. Staying out or returning to work as soon as possible can be the best thing for a worker's health, well-being and their recovery. It also minimises disruption to the workplace and can even reduce the cost of an employer's insurance premium. For more information, speak with your case manager or contact ReturnToWorkSA.
Okay, so really what that does is, I mean, that's information that's available on our website. It's high level, but it gives you a bit of a summary of how much of the new scheme hangs together.